May I thank my Professor Subramanya and CMR Law School for inviting me to speak on the subject. International law subject has great importance in developing the legal scholarship. However, it has not received much importance in the law schools, and I'm grateful that Professor Subramanya in CMR Law School has given its due importance. Usually, the subject receives greater importance when we discuss it in the context of current affairs. In international order today, nothing is more important than discussing on the Israel Gaza conflict and Russia Ukraine conflict. More important is both these two conflicts have reached the International Court of Justice. International Court of Justice, or judicialization of a dispute, what we call, has a lesser role in the international law as traditionally understood. People usually say international law is a vanishing point of jurisprudence because there is no compulsory jurisdiction for any court in international order which can summon people, or summon states, or which can compulsorily adjudicate the dispute based upon a complaint. Even if the International Court of Justice were to adjudicate a dispute, after submission to it by the parties by consent, the enforcement of the dispute is always not an easy task. Therefore, in this context, it was always viewed that adjudicatory mechanism in international law is a weak mechanism. But breaking all this traditional thinking, in the last 2 years, what we saw is the International Court of Justice has activated itself and has not only been entertaining disputes which were considered political, but has kept into the most difficult area of international order, that is the war. And in this background, the contribution of the International Court of Justice in developing rule of law based order than just a rule based order is important. And therefore, in today's lecture, I undertaken to analyze the role of ICJ in Israel and Gaza conflict. Before we go into the subject, which is a vast subject, and the material in the public field is not that definitive, but it is necessary to understand the background history to appreciate the intervention of the International Court of Justice from time to time in the last 9 months. To begin with, you are all familiar that the world witnessed two deadly wars, that is World War I and World War II. Everyone was at each other's neck. At the end of First World War, 3 great empires got dissolved. One of them is Ottoman Empire. As a result of dissolution of Ottoman Empire, also known as Turkish Empire, the Palestine, which was a part of the Ottoman Empire, became independent, and the League of Nations for the better administration of the territory created a mandate and vested it in the hands of Great Britain. So from 1918 onwards, for 3 decades, the British administered Palestine as a mandate territory. During this period, a lot of churning took place with regard to the demands of Jewish community for a formation of a state of their own in the land which they consider as their original land. For whatever reason, good or bad, the international community in 1947 decided to establish Israel as a land of Jews. There were several options where to be established, but finally they zeroed on establishing it in Palestine by a partition. The United Nations General Assembly in 1947 gave effect to this understanding in the international community, which was not unanimous, but which had some kind of an acceptance largely, to establish Israel by partitioning the Palestine into 2 parts. One is Arab-controlled Palestine, another is Jews-controlled Palestine. The Jews-controlled Palestine was named as Israel. But this partition plan was not acceptable to the Arabs. Arabs rejected it as unbalanced. The Jerusalem, with a historic city for Abrahamic religion, was decided to be made an international territory under the partition plan. Since the partition plan was not acceptable either to the Arabs or even Palestinian Arabs, it could not be implemented. Conflict broke out between the Jews and Arabs. At this stage in 1948, an agreement was entered into at Rhodes. It's called Armistice Demarcation, and a green line was drawn between Israel controlled territory and the territory which are not controlled by the Israel, which was termed as Palestine. This continued till 1967. In 1967, there was a war. In the war, Israel unfortunately occupied the entire territory which otherwise belongs to the Arab Palestinians as per the partition plan. This territory which Israel occupied in 1967 war is called occupied territory or Palestinian territory. This continued. In 1974, the PLO, that is Palestinian Liberation Organization, a political body, was recognized by the United Nations and was granted observer status in the United Nations. Subsequently, 2 accords were signed at Oslo, where they decided to implement certain measures to escalate the tension and achieve peace. And one of the immediate outcome of that was establishment of Palestinian Authority to govern Palestinian enclaves in the Israel-occupied Palestine. So these Palestine enclaves are Gaza Strip, West Bank, including the East Jerusalem. The Palestinian Authority is a semi-democratic body, continues to administer the occupied territories. In 2004, on the request made by the General Assembly of the United Nations, the International Court of Justice gave its opinion and held that construction of wall by Israel in the occupied territory in East Jerusalem is unlawful and illegal. This decision is significant because the decision was based on the United Nations earlier decision to treat erstwhile Palestine as two independent territories, one Jewish land and the Arab land. And therefore, whatever fell according to the United Nations as a part of Arab land cannot be occupied by the Jewish Israel, and its occupation and continued occupation from 1967 was termed as illegal and unlawful. It was a very significant decision in 2004 of the International Court of Justice. This decision tried to bring legalism into the conflict between Israel and Palestinians in their competitive fight for the homeland. Subsequently, in 2006, during the election to the Palestinian organization, that Palestinian Authority, PLA, a militant organization known as Hamas took control by defeating.
That's not my bag. My bag is with Betty.
By defeating Fatah, which was considered to be a less militant and more friendly to the peace initiatives. The Hamas takeover of the Gaza Strip began with a lot of problems. In 2012, the United Nations, in order to bring truce between both the sides, decided to grant non-observer status to the PLO, that is Palestinian Liberation Organization, not PLA, that is Palestinian Liberation Authority. Palestinian Liberation Organization, led by Arafat earlier, was considered to be a representative of the people, more acceptable to the Arabs. Therefore, it was granted a status of an observer in the United Nations. This is how the background history goes. And in the meanwhile, the Palestinian Liberation Authority, PLA, had declared itself as a state of Palestine, and it has found international recognition to large extent. Nearly 75% of the members of the United Nations treat PLA as a state. But neither PLA nor PLO are admitted as the full members of the United Nations because United Nations Security Council is not agreeing to such a membership because the permanent members are not in favor of admission of either PLO or PLA as a full member. Therefore, the state of Palestine, which was conceived under the resolution of United Nations way back in 1948, which at that time unfortunately was not acceptable to the Arabs and which subsequently became acceptable and which got subsequently occupied by the Israel, has come around and has become a state in the eyes of international community largely. Now let us see what led to the present crisis in the background of this conflict between Arab Palestinians and Jewish Palestinians identified as Israel. Since the beginning, there has been hostility on the question whether Jewish people have any right to the land in Palestine. The Jewish people claim their roots in Palestine, particularly Jerusalem, from the historical point of view. But Palestinians, Arabs, do not accept any such historical roots as a basis for claiming the homeland or their land as the Jewish land. This is a very difficult and a ticklish issue having regard to what Jews suffered Holocaust in the hands of Hitler during the Second World War. Therefore, this issue has an emotive appeal for both the sides, and it is a bit difficult for one to take side on this. But without going into the question, one must stick to the largely held opinion which has been in existence since 1948, that is, partitioning of Palestine, erstwhile Palestine, into Arab Palestine and Jewish Palestine, known as Israel. If we accept this, though Arabs did not accept in 1948, but subsequently they accepted, both the nations must exist and exist in peace and harmony. For this, the important condition is Israel, which has occupied the Arab territory since 1967 war, has to vacate. And there are already two opinions of the International Court of Justice. One in 2004, when International Court of Justice was called upon to pronounce its opinion with regard to the legality of building a wall in East Jerusalem. Secondly, was in 2024, when International Court of Justice was called upon by the General Assembly of United Nations to pronounce on the legality of continued occupation of occupied territory by Israel. With these two opinions, now it is clear that to the extent the United Nations considered as the territory of Arabs must be handed over to the Palestine, state of Palestine, or PLO or PLA, whatever the body which the international community recognizes as a duly representative body. And with regard to the other part, the peaceful existence of Israel should also be recognized, whether one may like it or not for different reasons, but its existence has to be recognized as per the decision of the international community. If these things are considered, probably there will not be much problem. But politics is not that easy. International community does not fully function on logic. It does not even function on rule of law. There is a continuous effort to at least instill seriousness in the states to conduct themselves in the or by adhering to the rule based order, if not rule of law based order. But as we all know, several people treat international politics as more a power politics due to the security issues and are not willing to submit or account themselves to the rule based order or rule of law based order, be it as it may. Now, let us see what the International Court of Justice had to do in the recent past. Due to the existing hostility between the Palestinians and the Jews, on sometime on 7th October 2023, a surprising deadly attack took place on Israeli civilians, killing nearly 1,200 civilians, unarmed civilians, which included women and children. This ghastly act shocked the world. There is no provocation, immediate provocation, for the Hamas, a militant organization in control of the Gaza Strip as a de facto ruler almost, to attack civilians, Israelis, and kill them. Naturally, Israel retaliated. On 13th October 2023, Israel announced its decision to evacuate all Palestinians from Gaza Strip. This is again an excessive reaction. You cannot evacuate all civilians of nearly 20 lakh civilians from Gaza Strip because some militant Palestinians had taken arms in their hand and resorted to violence. The war started. It's called evacuation plan. In the last 9 months, we have seen 41,000 Palestinians have been killed, more than 3 lakhs have been wounded, and more than 1 million have been displaced from their homes. The tragedy is enormous, which cannot be explained in words. So this situation of killing unarmed civilians, innocent civilians, babies, bombing the hospital, even preventing international community from supplying aid to the Palestinian, led to the opinion in the world around that what has been going on in Gaza in retaliation for the misguided acts of some Palestinian terrorists is nothing but a genocide. We all know genocide is a heinous crime because it is not only killing of the people, it is killing of the people or targeting people based upon their ethnic identity or religion. South Africa took up the matter to the International Court of Justice on 29 December 2023, filing an application asking for declaratory reliefs to declare that the war against Gaza declared by Israel is illegal, and those who are responsible for genocidal act in the territory of Gaza, that is occupied territory, should be prosecuted and dealt with or made accountable to law. South Africa also asked for provisional measures, immediate cessation of the military activities, and supply of aid to the people in Gaza. The International Court of Justice immediately responded to the complaint filed by South Africa. One may ask the question, what business South Africa has got in a conflict between Israel and Palestinian Authority or Palestinian State or Gaza Strip? South Africa says, as a responsible member of the international community, it's a party to the Convention on Prevention of Genocide. And under the convention, Article 9 states that International Court of Justice shall have jurisdiction with regard to the differences in the implementation or execution of the convention. As we all know, International Court of Justice really doesn't have a compulsory jurisdiction. It's not like a civil court that I go and file a suit and make X a defendant and court issues summons calling upon him to explain why a decree should not be passed against you as prayed by the plaintiff. There is no such compulsory jurisdiction for the International Court of Justice. The heart of international adjudication is consent, either a prior consent or a consent to submit to the jurisdiction. In this case, South Africa argued, which was upheld, that the Genocide Convention in Article 9 provides for submission of the dispute to the International Court of Justice. Therefore, there is a prior consent by Israel, which is a party to the convention. And therefore, International Court of Justice has jurisdiction to look into the question whether Israel, in the name of tackling terrorists, has far exceeded the limits and is involved in genocidal acts violating various provisions of the Genocide Convention. The International Court of Justice on 26 January 2024 unanimously upheld the locus standi of South Africa and has also unanimously said we have the jurisdiction. This is very important because International Court of Justice has ad hoc judges from Israel also. Since the rule says that if one of the disputing party does not have a judge on the bench, it has a right to nominate a judge. Accordingly, Israel nominated one of the well-known jurists, Aaron Barak, as an ad hoc judge. And it's a great victory to the impartiality of the ICJ and to the impartiality of Barak that he agreed that South Africa has a locus standi and ICJ has a jurisdiction. However, when it comes to the what relief to be granted, provisional measures, the International Court of Justice did not agree with the reliefs which South Africa had asked. It formulated its own measures and passed the order. Justice Barak, except in respect of one relief, providing humanitarian aid to the Palestinians in Gaza, did not agree with any other directions. So as another judge from Uganda did not agree. The orders passed by the International Court of Justice are important, although narrower. This is the first time that in a war-like situation, when everyone thinks there is no rule of law, there is no rule or anything, that International Court of Justice decided to step in and pass the order. And I must tell you that the decision of the International Court of Justice has found its appreciation from the international community at a large. So, the first order passed by the International Court of Justice on 26 January 2024, directing humanitarian measures for the civilians in Gaza, is a great step in building the reputation of the institution and its relevance in the coming years of international order. Then on 16th February 2024, there was a further request for an interim order with regard to the humanitarian measures, particularly the situation arising for Rafah. The court passed further directions. Again on 28 March 2024, court passed further directions against Israel and reiterated its earlier order. On 30th April 2024, International Court of Justice dismissed the application of Nicaragua against Germany, which Nicaragua alleged has been supplying arms to the Israel. The court said it is not necessary to consider at this stage this larger question. We are more concerned with humanitarian supplies to the people in Gaza than who is helping Israel with arms and other things. Subsequently, on 24th May 2024, ICJ passed further interim order, and in this again they reiterated their order, and by majority the ICJ said halt military offensive in Rafah. It's a very significant order, almost injuncting Israel from stopping the war at Rafah. And ICJ further directed Israel not to impede any fact-finding body from performing its job in Gaza. So the order of 24th May 2024 directing by majority that Israel should halt its military offensive in Rafah is very significant. This order arose by looking into the factual situation, the way the civilians were getting butchered, the way the hospitals were bombed, the way schools were bombed. It was considered necessary for International Court of Justice to restore the conscience of humanity, and it indeed interfered. So these are the interim orders which International Court of Justice passed to control the military offensive of Israel in Gaza, and more was directed for humanitarian assistance, but also at some stage in Rafah, an injunctive order was passed to stop military offensive. After this, on 19 July 2024, International Court of Justice took up the pending resolution of the General Assembly for advisory opinion on the question of whether continued occupation by Israel of the Palestinian area since 1967 is legal or not. If you recall, I have already said in 2004, when UN General Assembly passed the resolution seeking advisory opinion of the International Court of Justice on the question whether wall constructed by the Israel in East Jerusalem, which is part of the West Bank, Palestinian territory, is illegal or not. The International Court of Justice, by majority, held that the construction of wall is illegal in the occupied territory and therefore it must be undone and certain compensation to be paid. So in this background, the second opinion of the International Court of Justice on the question of continued occupation of the Palestinian territory by Israel became important. And the opinion came strongly in favor of Palestinians. Firstly, the International Court of Justice said, that is by a majority of 11:4, continued presence in Palestinian territory is unlawful. In very uncertain words, made it very clear that the continued presence of Israel in Palestinian territory is unlawful. Because as we all know, this Palestinian territory is a territory demarcated in favor of Arab people by the UN partition in 1948. Secondly, the ICJ said Israel is under obligation to end unlawful occupation of Palestinian Authority. It is not only unlawful to occupy it, but you are also under an obligation to get out from the Palestinian territory, is what the ICJ said. This decision is by 11:4. 4 dissented, 11 favored against Israel. Thirdly, ICJ said Israel is under obligation to seize all new settlements and evacuate all settlers from the occupied territory. What has happened is, subsequent to the occupation of Palestinian area by Israel, crossing the Green Line in 1967, there have been Jewish settlements in the area which really belongs to the Arab Palestinians as per 1948 partition. So the International Court of Justice has to say creation of new settlements trying to put Jewish population in Palestine is not justified and this must stop. So this decision had a little larger support in the International Court of Justice. 14 voted in favor, only one judge voted against. Then ICJ said Israel is an obligation to make reparation for damages to all natural legal persons. That means whatever is caused to the Palestinian population, the deaths, injury, or even destruction of their infrastructure, Israel is an obligation to pay for it so that they are compensated and justice is met. This decision is again as a larger support with 14 judges supporting, only one judge dissenting. Then ICJ said all states and United Nations are under an obligation not to recognize the situation arising from the illegal occupation of Palestinian territory by Israel. So a direction at large is issued, a declaratory direction that neither the United Nations nor any of the country should recognize the illegal occupation of Palestinian territory by Israel. This is how the ICJ responded. One more direction ICJ issued was, ICJ said the General Assembly and the Security Council of United Nations are under an obligation to consider modalities and further action required to end unlawful occupation of Palestinian territory by Israel. This decision had the support of 12 judges, but 3 judges dissented. So this is how the International Court of Justice has played its role in the war-torn Gaza by passing provisional orders or interim orders in a complaint filed by South Africa alleging that what is going on in Gaza in the name of catching some terrorist is nothing but a genocide, killing tens and thousands of innocent civilians, injuring them or displacing them. Therefore, this act of mass killing of a particular community, that is Arabs, who constitute an ethnic group, must end. In response to the complaint, interim order was passed, and interim order was also passed to cease military action in Rafah, and subsequently, in the pending advisory opinion sought by the United Nations General Assembly, the ICJ has said continued occupation of Palestinian territory by Israel is illegal. So this is how a semblance of legality is sought to be infused by the International Court of Justice. Ultimately, it is for the states, United Nations, to proceed from the declaratory opinion of the International Court of Justice. And we all hope that the decisions are implemented. But the question remains, how and what happens? First and foremost, it is necessary in the international community to sensitize that both terrorism and genocide are unlawful. We can't say only genocide unlawful and quietly support terrorism. Or we can't say terrorism is correct and as a reply, genocide is justified. Both are enemies of the international order and enemies of the civilization which this world has struggled to bring about in the last 10,000 years. Therefore, it is necessary for one to understand, and each citizen in the world must be sensitized to accept the fact, forgetting the other things, whatever may be historical grievances, that terrorism is not the way. Any demands which you have in this world have to be met, have to be pursued in a non-violent manner as Mahatma Gandhi in India did. And secondly, whenever you have a duty to use your force, you are justified in using a force, you must do it in a proportional manner. It should not be disproportionate to the situation, resulting in a genocidal act. Such a genocidal act attacking the civilian population is unacceptable to the international community. So this sensitization ought to be instilled in the international community. Then Hamas, which is a militant organization, must come forward and all its terror activities, and Palestinians in particular should swear by peace and Gandhian method of non-violent activities to pursue their goals. Thirdly, the advisory opinion of the ICJ, which holds that occupation and continued occupation of the Palestinian territory is unlawful and illegal by Israel, must be implemented by the United Nations by evacuating all Israeli forces from Palestinian territories. Fourthly, the Israel, which has exceeded in its actions in Gaza, wherever it has caused misery to the people, particularly bombing the schools and hospitals, the concerned persons must be held accountable to restore confidence in the Palestinians. Next, United Nations Supreme Security Council must act immediately to bring a peace and stop the war, as even Secretary General Antonio Guterres has recently appealed. With this, I think the ICJ has played a significant role in promoting rule of law based international order, which is a progress from rule based international order. And the International Court of Justice has made itself relevant by stepping in at a crucial moment to ensure humanitarian aid and supplies to the people in Gaza, has contributed immensely to the development of international law. We only hope that in future, whenever the International Court of Justice intervenes in such a situation, its orders must be strictly implemented by the Security Council. At present, Security Council asserts a discretion to implement the orders of the International Court of Justice. This is unfortunate. No such power is available to the Security Council to sit in appeal over the decision of the International Court of Justice. The word may in Article 94 should not be interpreted in a manner vesting a discretion in the Security Council to decide whether to act upon or not, whether to implement or not. Once an International Court of Justice has passed order, the Security Council is bound by it. Article 27, Clause 2 very clearly says the permanent members cannot exercise veto power in procedural matters while implementing the decision of the judicial bodies. Implementing decision of the judicial body is a procedural matter. Because if the decision is binding, if the Security Council has no power to review the decision, then implementation of the decision or execution is an obligation. And therefore, it follows that the Security Council has no choice but to treat this as a procedural matter and deny veto power to the permanent 5 powers in the world. Hope this will follow as the world gets sensitized with rule of law. Thank you very much. I hope I have not bored the students.